Dear participants to this conference, let me first thank the organizers for their kind invitation. I would have loved to be with you, but unfortunately, my duties as president of the European Law Institute have compelled me to be somewhere else today. Following, however, the kind proposal of the organizers, I've decided to record this presentation to present to you some ideas on the topic of conditio causa data causa non secuta and its link with innominate contracts. I hope that, despite the distance and the digital means of communication, you will enjoy my presentation. Having written on innominate contract, with a specific interest on causa, and having recently written on error in conditio indebiti, my attention was recently triggered by a book by Caroline Duret. Her main thesis, written in French, is to revisit some of the main disputed points in the field of conditio causa data causa non secuta and the cause in innominate contracts. My presentation is not a review of her work, but was triggered by it, reason why I will refer to her at many places to explain why her work triggered reactions, often with different results. Let me first begin with one of the famous texts in this area. The Juris Pomponius distinguishes in a very famous text between condictiones ob causam and condictiones ob rem. This excerpt is, however, not contained in Digest Title 12.4, which deals specifically with condictiones causa data causa non secuta, but has been incorporated by compilers in Digest Title 12.6, De Condictiones Indebiti. Let me remind you that there is no specific title on condictiones ob rem, which makes the whole endeavor even more interesting, and the decision of Justinian compilers to keep Pomponius' excerpt in the digest even more enigmatic. Pomponius' excerpt reads as follows, and here the text, Digest 12.6.52. I give directly the translation. We give either on a basis ob causam or for a purpose ob rem. An example of giving on a basis ob causam founded in the past is where I give because I have obtained something from you or because something has been done by you. Here, there is no recovery even though the basis proves false. But a giving for a purpose, or rem, is done in order that something shall happen, and if it does not happen, recovery lies. Pomponius creates here an opposition between situations where a performance has been done ob causam and another performance has been done ob rem. Of particular interest in this passage is the word causa. It is polysemic and it is well known and will not occupy us any further. However, two elements make this excerpt particularly striking for the reader. Firstly, the word causa is understood as something to be found in the past. It is a ground or a basis for performance. The word basis, causa, referring to the past, of course. In short, someone gave me something or did something for me, potentially with the intention of receiving a performance from me in return. The perspective from which Pomponius observes the situation is that of who receives this past performance, first performance, and then performs on that specific ground. What happens if such a basis proves false? Falsa causa sit. One example of such an occurrence would be if a third party had a better right on the goods which were given to me. In that case, I will obviously lose the goods handed over to me, potentially in a reivindicatio claim, but furthermore, according to Pomponius, I have no right to recover the goods I transferred to my counterpart. Subjectively, the goods were transferred ob causam, the causa being the belief that the one who transferred the item was the owner or had the right to transfer it to me. One could then raise the issue of mistake on an essential ground of performance. Objectively, however, the item was received and the causa i.e. the belief that the transferring party had the right to transfer it, was there. The fact that it later proved false or ceased to exist has no relevance since, according to Pomponius, the causa lies in the past, praeteritam. It does not need to exist in the present. Secondly, this example of a third party raising better rights on transferred goods and the solution given is harsh. It triggered, however, the regime of eviction. In emptio venditio contracts, the buyer could induce the conclusion of a stipulatio duplae or a stipulatio rem habere licere to protect itself against third-party rights. But in Pomponius' excerpt, there appears to be no sales contract. The situation described by Pomponius might, however, translate as a performance of an innominate contract, for example, a permutatio, whereby both parties execute their respective performances and then an eviction occurs. Pomponius' position in that case is that there is no right to recover what was performed in the second place in counter-performances of the goods evicted. Even based on a pre-existing cause, which then ceased to exist, there is no condictio ob causam and therefore no restitution. This potential link to innominate contracts recalls another famous passage by Ulpian in its Treaty on Pacta, Digest 214.7. One excerpt in particular plays a central role in the study of the concept of causa. It is the following, Digest 214.2.2, which I will read in my translation, or better, the translation by Geoffrey McCormack. But even if the matter does not fall under the head of another contract and yet a ground, causa exists, Aristo, in an apt reply to Celso, states that there is an obligation, where, for example, I gave a thing to you so that you may give another to me, or I gave so that you may do something. This is, Aristo says, a synalagma, and hence a civil obligation arises. And therefore, I think that Julian was rightly reproved by Mauritianus in the following case. I gave Sticus to you so that you would manimate Pamphilus. You have manimated. Sticus is then acquired by a third party with a better title. Julian writes that an action in factum is to be given by the praetor. But Mauritianus says that a civil action for an uncertain amount, that is a praescriptio verbis, is available. For the contract described by Aristo with the word synalagma has been made, and hence this action arises. The situation described by Ulpian is quite similar to the one we developed based on Pomponius' excerpt. One person, I, hands over the slave Sticus, while another person, you, manimates the slave Pamphilus. One could say here that the person who received Sticus performed on the basis of a causa. Despite their own performance, they then find themselves evicted from their ownership of Sticus due to someone else's better rights on the slave. Its causa could be therefore considered as falsa. Ulpian's approach, however, differs from Pomponius' one. He brings both performances together and finds ground for an actio, more precisely, an actio praescriptis verbis instead of an actio in factum civilis or a condictio ob causa. The key element in Ulpian's passage is the synalagmatic nature of the relationship between the parties, which eventually brought the idea that there should be a specific civil action in those situations. Given the similarities of the described cases, it is intriguing to note that Pomponius only considered the question of restitution through the granting of a condictio and no action in factum. It is doubtful indeed that Pomponius did not consider the synalagmatic nature of the situation he was dealing with. It is more probable that he recognized the synalagmatic nature of the contract, but considered that because the performances had already taken place, the issue could no more be addressed by a contractual action such as the actio praescriptis verbis. It is of course also possible that Pomponius, causa falsa est, does not in fact refer to a case of eviction. It could be envisaged, for example, that there is a performance that ultimately did not happen contrary to what was originally thought. This would, however, not explain Pomponius' insistence on the fact that causa refers to something in the past. One could also imagine that performance might have been recovered beforehand for mistake or another reason, but this seems also quite hypothetical. At any rate, there does not seem to be an obvious reason why Pomponius discarded the possibility of an analogy with an eviction case, apart from the fact that remedies against eviction might still be triggered mainly by stipulationes dublae or stipulations called rem habere licere, which might have not been stipulated in the present case. A second text by Paul helps further our reasoning. The text reads as follows, Digest 12:6, 65:2. Further, that which is given on such a basis as, say, that I thought the donnee had rendered me a service in a business connection when in fact he had not, cannot be recovered, because I wanted the gift to be made, albeit I brought myself to it for wrong reasons. Once again, the situation described here is similar to one in Pomponius' text. Paul considers someone giving something on the basis, ob causam, of a service they thought had been rendered to them in the past. One example would be that of a beneficiary wishing to express their gratitude by paying an honorary to an attorney for having presumably worked on their case. If it were to appear after payment that someone else had provided such a service and not the attorney in question, Paul concludes that there is no right to recover for the payment of the honorarium. In this hypothetical, the honorarium is clearly paid without being due. The presumed donor chooses to donate based on false information. Once again, there might be an argument for a mistake as to the ground of payment here, but Paul does not consider that option. The jurist limits himself to the topic of the condictio and rejects the possibility of restitution. The donation, wrongfully motivated as it may be, is final. At the time, error in motives were not yet a ground for rescission. It became such in certain modern legal systems when the error on motives is considered fundamental, such as in Swiss law in Article 24, paragraph 1, number 4 of the Swiss Code of Obligation. Such regime has been inspired by the Voraussetzungslehre by Winscheid, as I have presented elsewhere. Paul's excerpt follows Pomponius on two essential points. First, both excerpts consider the causa as something belonging to the past. And second, both authors remove the question of innominate contracts from their analysis. Understanding this second point is a delicate exercise, since both passages only give a partial rendering of the concrete situation which brought them about. Both situations could accommodate an innominate contract in the do ut des or do ut facias form. The determining factor here is that both Paul and Pomponius are looking at their respective situations from the perspective of the party who receives the first performance. It is the dare. If this dare has truly existed or had at least been valid, then one might have assumed the existence of an innominate contract. It is not the case here. Neither Pomponius nor Paul have mentioned an innominate contract. At least Paul could have done so, as those figures were well known at his time. Either there is in fact no dare, despite what was previously assumed, or the dare either originates from someone else or at the very least is not based on a pre-existing and necessary consent. In such situation, there would be an issue of motives. It seems to me, however, that the issue of innominate contracts might simply not be relevant here. In an actionrechtliches Denken The idea of an indeterminate contract serves only to determine whether the one who performs a dowry or factory has an action to force the one who receives such dowry or factory to perform his part of the deal, to perform, in other words, the agreed counter-performance. In Pomponius and Paul's excerpts, however, the focus is on the second performer, when he has already performed his part of the deal. When looking at the relationship between the parties from that point of view, there is no doubt to find grounds for an action that triggers performance. The only relevant question is whether the second performer can recover his own second performance. These are two different perspectives from which to analyze a single relationship. The facts may be the same, but the procedural question is entirely different. In the first perspective, the first performer asks for the second to perform its part. In the second perspective, the second performer asks for recovery of its own performance. Let's come now to the case of restitution. In her recent book, Caroline Duret has attempted to determine what may trigger whether one has a right to recover his performance. Through the collation of many texts, she identifies the type of datio performed as a key consideration, as well as the degree of completion of the expected counter-performance. According to her, when the counter-performance is non secuta, the collated text systematically conclude that there is a right to repeat the initial performance. One exception is the case of Digest 12.665.2, where the datio is performed ob causam, but such causa is said falso existimans. Caroline Duret does not explain why restitution is not granted in this case. It could be argued that there is in fact a causa to the datio and consequently a counter-performance as expected. Indeed, this counter-performance is not carried out by the correct person, but some facere has indeed been done, which in turn triggers the dowry by the beneficiary of the first performance. In proper terms, then, there is indeed a causa, even if it is not the one subjectively envisaged by the beneficiary, since the motive for the dowry is false. To clearly distinguish this situation, it is worth examining an additional case where right to restitution is granted to a performer ob causa. The text reads as follows, Digest 12.6.23.3. Suppose that after having settled, someone is nevertheless condemned. That must happen from fraud, but the judgment is still valid. In the case of settlement before joinder of issue, one can meet an attempt to join issue with a defense of fraud. And even after joinder, it is still possible to rely on the defense of supervening fraud, for it is fraudulent deliberately to set out to get more after settlement has been reached. Hence, after condemnation, the money paid on the basis causa of the settlement is recoverable. It is true that this is a giving upon a basis causa, and that recovery is not granted where the basis of such a giving does materialize. But here it does not, for the settlement is not effectuated. When recovery begins, the defense of settlement gives way, for it is not right that both the defense and the right of recovery should coincide. End of the translation. Alpian considers here that the settlement agreement is a form of giving upon a basis, ob causam. He also adds that the recovery is not granted where the basis of such a giving does materialize. In principle, then, when the causa is secuta, there is no recovery. In the given case, however, the settlement agreement was indeed concluded, but parties intended for it to mean no further action in court. Yet one party did go to court nevertheless. In a way, therefore, the causa here is non secuta, as the settlement did not produce the expected result. Literature around this text is partly made obscure for two reasons. First, some authors consider that the condictio causa data causa non secuta is one of the names under which the classical condictio ombrem later became known. Second, even if one rejects this approach, among other reasons, because Pomponius mentions the datio obrem in Digest 12.652, our initial text, the delineation between the conditio causa data causa non secuta and the conditio obrem is not always clear. If one gives something to someone else, hoping for a return performance, it is a typical situation of an innominate contract under the form do ut des or do ut facias. The perspective, however, is now that of the first performance. He gives ad rem, hoping for counter-performance. If he does not receive the expected counter-performance, non secuta, then, as mentioned in Pomponius' first text, he may ask for restitution of what was paid. He could also, however, insist on receiving the agreed upon counter-performance and thus file an actio praescriptis verbis or an actio in factum civilis, as stated by Ulpian in his excerpt, Digest 2.14.7.2. The same situation applies in the case of nominate contracts, such as in the case of an emptio venditio, where a down payment or a payment to secure the deal ara has been performed, but the sales contract is ultimately invalid, as it appears from the following excerpt by Ulpian, Digest 19.1.11.6. The case is quite long, so let me just summarize it. Ulpian is very clear in this excerpt, where both parties agree that the contract is void irrita. Even if Julian considers that the ara can be retrieved by an actio exempto, Ulpian suggests that a condictio sine causa could be possible. In his view, it is almost as if there was a causa which then ceased to exist. As such, and in the absence of a causa, even a ring could be recovered through a condictio. The same situation applies in the case of nominate contract, such as in the case of an emptio venditio, where a down payment or a payment to secure the deal, ara or arae, has been performed, but the sales contract is ultimately invalid, as it appears from the following excerpt by Ulpian, Digest 19.1.11.6. A purchaser of wine gave a fixed amount of money as arae. Later, the parties had agreed that the sale was void irrita. Julian says that there can be an action on emptio venditio to force return of the arae. Later, the parties had agreed that the sale was void. My question is, if a ring was given as an arae and the ring is not returned after the sale was carried out, the price having been paid and the object delivered, under what action may suit be brought? Should a condictio be brought on the theory that it was given for a reason, ob causam, which has now lapsed, or should there be a suit on the purchase, exempto? Julian would likewise say there can be an actio exempto, but a condictio will also be possible since the ring is in the seller's hand without a reason, sine causa. Ulpian is very clear in this excerpt, where both parties agree that the contract is void, irrita. Even if Julian considers that the ara can be retrieved by an actio exempto, Ulpian suggests that a condictio sine causa could be possible. In his view, it is almost as if there was a causa which then ceased to exist. As such, and in the absence of a causa, even a ring could be recovered through a condictio. The expression sine causa is not used here in a technical sense, but refers to the fact that a future agreement-based performance did not take place. Even if the words ob rem do not appear here, there are good reasons to consider that the condictio ob rem could have been filed, since the performance of the ara had been done in anticipation of the counter-performance. A future counter-performance, to recall Pomponius' position in Digest 12.652. In her book, Caroline Duret also interprets the performance of the ara as done in anticipation of a counter-performance, but without explaining why. She does not, however, recognize that the counter-performance is necessarily taking place in the future. Let me come to my conclusions. Based on the selected text, one could conclude that the main issue is one of perspective. Specifically, when faced with a relationship which is potentially an innominate contract, one should distinguish between the perspective of the beneficiary of a past or first performance, who then performs ob causam, and that of the author of this past performance who is performing ob rem. If a performance which is carried out ob causam does not yield its intended result, non secuta, then its author has a right to recover its performance. Several other texts support this position. However, if the causa at the origin of the performance is purely subjective, i.e. a motivation that relies on mistaken grounds, ob causam falso existimans, then there is no right of recovery and the performance is final. One mitigating solution to this otherwise harsh conclusion could be to consider an essential mistake as to the motives or the absence of a subjective cause in French law, which may justify avoidance of the contract and therefore granting of a claim for restitution of what has been paid. But that conception appeared only later, as mentioned earlier. Jurists express the idea of a performance given in consideration of a future counter-performance in two different ways. The first way is the one chosen by Alpien in Digest 21472. He underlines the synalagmatic nature of doudes and doude facias to justify the right to force counter-performance. By looking at the situation through the eyes of the first performer, Alpien grants the right to claim the expected counter-performance by granting an actio praescriptis verbis or an actio in factum civilis. The second way focuses on the first performer's wish to get his performance back by means of a condictio. Pomponius, as well as others, would then qualify this first performance as ob rem. In this case, if the res, the bilateral agreement, the innominate contract, if one would take a substantive approach, this res does not materialize. The first performer will be able to repeat to get restitution of his performance by means of a condictio ob rem. This sounds very plausible and is also supported by a large view of authors. The point of identifying whether a performance is done ob causam or ob rem, however, remains open. Caroline Duret negates the possibility of predicting whether one might recover their performance based on the type of his performance. This approach may ultimately obviate the fact, however, that in a synalagmatic or potentially synalagmatic relationship, the condictio ob rem is the first performance perspective who wants to get restitution, who wants to get his performance back, whereas the condictio ob causam is the second performance perspective who benefited from the first performance and wants to get his second performance back. Despite what Duret writes, therefore, temporality is central to the understanding of the interrelation between the text on synalagmatic contracts, doudes, and the text linked to restitution for unjust enrichment, do quod des, for performance ob causam. In other understanding, therefore, Digest 19.1.11.6, in fine, constitutes the keystone to understand this interrelationship. Of course, the interplay between causa in the field of synalagmatic contract and causa in the field of unjust enrichment has further ramifications and potential aspects. It seems important, however, to understand that in the former case, it relates to the first performer perspective, and in the latter case, it relates to the second performer's perspective. And with that, I wish you a wonderful continuation of your conference, and I thank you for your attention.